government lawyer moves into private practice, and a private lawyer moves into government practice. And what that means is you're going to see that when we do this analysis, it's going to be also a review of what we did with 1.9 when we were talking about a formal representation. Because what you're doing as a government lawyer may impact what you did as a private attorney. And the same thing when a current government lawyer comes from private practice. Something that you're doing for the government may impact something that you did in private practice. So we'll be talking about that. And that will be the last component of conflicts. So we've done current conflicts, formal representation conflicts, or successive conflicts. This past chapter, chapter 9, was those individual conflicts between an attorney and client, primarily with money. We looked at 1.5 a lot, tried to determine what was an unreasonable fee, noted that those are set out in 1.5. Those factors are not exclusive, but it's something that we look at. Then we looked at more specialized relationships under 1.8, noted that a lawyer really should not enter into a transaction with a client, but if he or she does, there are three writings required: fair terms in writing, seek independent counsel in writing, and then you formalize the entire agreement with informed consent in writing. That's what Rule 1.8. So we did an unreasonable fee on page 381. And there, what was driving that case is there's $70,000 in damages with $60,000 in fees. So was that unreasonable? We said yes. And we also pointed out other rules that were broken that could have avoided this unreasonable fee. Communication is first and foremost. And notice how communication determines the scope of representation, also competence and diligence, because if you don't communicate with the client, you may keep doing the same thing over and over again, or maybe pursuing the wrong objective. Another thing that the attorney did in this case, in unreasonable fee 9.1, was that he didn't really consult with the client about what type of course of action he was going to take. So he went through an entire mediation process with no results, costing a lot of money. So we said that is not something that an attorney would do. And then from there was a large part of this chapter talks about improper billing practices. We noted that contingent fees must be in writing, and that's really interesting when you compare it to a general fee, which is not required to be in writing, and even a fee change preferably in writing. But contingent fees must be in writing because this is one of the rare instances where an attorney has a stake in the outcome of the litigation. And so that contingency fee in writing has to talk about the percentage, how that will accrue, what will be remitted to the client, and whether or not expenses will be deducted before or after. And we noted that that is very important. If you look on page 400, the client gets more if the fee is calculated after expenses are subtracted. Then we went through Rule 1.5 also to emphasize that you cannot have contingent fees in criminal cases and divorce cases. And then we did problem 9.2, an impoverished client, noting that we could not extend fees to a client unless they're for trial or litigation expenses. Noted that some jurisdictions take a broader view of expenses. And that was pretty much it for that chapter. So we are going to start Chapter 10, conflict issues for government lawyers and judges. So I want to spend the first portion of this class looking at Rule 1.11 and what it does. So this is going to be important. You watch around, well now, it's going to have people leaving government, going back to private practice for whatever reason, flipping around. And so in an election year, this becomes really important. So you have people leaving government, going back into government, coming back around, and they have baggage with them. And so notice this class is fairly new. It comes out of Watergate. There was no professional responsibility class until Watergate. So then you just, as a lawyer, old school lawyer, like in the early part of the 20th century, you just had to know the canons and look at them every now and then, and that was that. So very rare you have this whole regulatory framework springing up. But now we're looking at Rule 1.1. These are special conflicts of interest. Notice this, for former, this is what I mean all the time when I say you have to look forward and backwards. So this is one of those real times where you're going to see even within the rule it says 1.7 applies as well as 1.9 when we get to a portion of the rule. So these are special conflicts for former and current. And it says government officers and employees, just to make sure you know that it applies to everyone across the board. Higher ups, you know, the Deputy Associate General, Attorney General for civil litigation, all the way down to a line attorney in the Justice Department. Moving back and forth, that's what we're concerned about. So special conflicts of interest for former and current government officials. And so we're going to look at 1.11a, and we're going to look at 1.11b. And we're going to look at 1.11c. So I'm putting this up on the board because the rule is broken down in such a way that it focuses on different things, but it builds upon itself. And then 1.11b. So this first scenario, 1.11a, is when that former government employee moves to private practice. Former government employee moves to private practice. That's just paraphrasing the rule. And so what we're focusing on here is the conflict. This paraphrasing the rule. So if you look at 441 in your book, it sort of breaks it down. This is a less demanding standard. So former government lawyer moves to private practice, and it says, except as law may otherwise expressly permit, a lawyer who has formerly served as a public officer of the government is subject to 1.9c. What's that? So there's a lot of cross-referencing in this rule, so I'm just sort of emphasizing the level of care. So this is a former government lawyer who moves to private practice, except as law may otherwise expressly permit, a lawyer who has formerly served as a public officer or employee of the government is subject to 1.9c. So my first question is, what is 1.9c? See, lawyers have a tendency just to read, oh, subject to 1.9c, okay, but I'm still looking at it. You have to, the thing is telling you is you have to look back and forth. We're looking at 1.9c, And this is expressly telling us that we are going to spend some time looking at former representation like we did in chapter 8. So what's 1.9c tell us? We know it's formal representation because that's what 1.9 is. It's more, go ahead.
It says that when you wrongly represent someone, that you're using them to not use information inappropriately for.
Okay. Shall not use this information to the disadvantage of the former client? Can I use information to the disadvantage? So we can't in private practice take something that we did in government and then use that against our former employer, the client, the government. So notice this is the first indication that you get that we are always going to be looking at formal representation in this as well. So that's 1.9c and what? Look at that, that's good, thanks.
Shall not otherwise represent a client in connection with a matter in which the lawyer participates personally and substantially as a public officer or employee unless the appropriate government agency gives informed consent confirming right to representation.
Okay, so I'm just going to put the catchphrase on. I'm not going to put the entire rule. You have that in front of you. So you got to break all of these down so we'll know how we are covered. And then you said unless the appropriate government agency gives informed consent confirming right. So you're doing something privately, you get permission from the government because of this conflict. They say it's okay, we can move on. But they may not say okay. But how do we know about this shall not? Shall not otherwise represent a client in connection with a matter in which the lawyer participated personally and substantially. This is that government work as a public officer unless the appropriate government agency gives informed consent. And so if you look on page 442, you have a great summary of this long-winded rule. They sort of taken it and broke it down. And it says this. But this is what we're going to break down. We have to figure out what a matter is. What is participated personally and substantially? What does that mean? But on page 442, you get a good summary. If the lawyer participated personally and substantially in work on a matter while working for the government, the lawyer may not represent a client, private client, in connection with that matter unless the government gives informed consent. That's right on page 442, top of page 442. But, and that's good. So we get the former lawyer going to private practice. That government lawyer may learn something or whatever. I'm not talking about a specialized type of information. We're going to talk about that later when we talk about 1.11c. But the lawyer may have gained something in experience with the government that now can be used in private practice against the government. We have to figure out the matter and personally participate. How do we figure that out? What do we do there? What is a matter? Any comments, help us? Yeah.
It's actually part of the rule of subsection E. The use of this rule, the term matter includes the judicial or the proceeding, application, request for ruling, or
Good.
determination.
So pretty broad, and that's not exhaustive. So proceedings, all of these things. And it's in the rule and it's referencing comment too. You see 1.11 y'all. That's good. What is participated personally and substantially? How do we know that? And so, this is another one of those situations where the drafters just said, well, it sounds good personally and substantially, participated personally and substantially, without really giving us language, a definition. So what's the definition? What does it tell us on page 444? It tells us that there's no definition, but there must be some way for us to figure out what is personally and substantially. So notice, if the government lawyer moves to private practice and has just had sort of a tangential relationship to this previous matter that he worked on for the government, maybe read a one-page memo and then consulted with a partner about what he thought about the memo, interpreting that. That probably wouldn't be personally and substantial enough sort of preclude representation without the consent of the government agency. So we wouldn't even need to go down the road of conflict there because it wouldn't be enough. But how do we figure out if it's enough? That's the problem. So you see from the book that in terms of drafting this rule, I think the ABA sort of just lifted some language from a federal statute, plugged it in there, and we don't have a definitional section. So we want to figure out what is personally and substantially. What do you think that means? What do you think? Ms. Horntel, what do you think?
I really don't know. I'm not sure.
Take a guess. Push it a little bit. Personally and substantially.
Probably, wild guess, but may mean that
So my little hypo, where I've just looked at a memo on government practice, I know I'm going to Frost Brown Town in 2 weeks, and this is my last assignment. I just look at it, yeah, that's good, that's what I thought about it, that's that, and then I leave, I go to private practice, and then the partners ask me, well, where'd you work on? Yeah, I worked on this, and it is definitely a matter that is related to what I worked on in the government. Then we say, okay, we have to really check about, first, the type of information. We can't use the information to the disadvantage of our former client, but also my involvement in it. And so maybe the information is important, but have I had enough involvement in it to preclude me from actually working on it? What do you think?
I think it depends on how much the lawyer is involved in the case.
Yes.
So like the former client privilege, like attorney-client privilege with the when the attorney was working in the government, versus like if they had like if they know all this stuff about that situation versus working on it like on the opposing side, that's unfair.
Well, yeah. But how do we measure what I've done? So I guess the question is, it's sort of a matter. I said in my hypo that it's related to what I did. It's a proceeding or something. Now I've quote switched sides. I may have information that disadvantages the former client, but the question is, in order to make that determination, you see, and I have to be personally and substantially involved. So what does it say about that involvement for you?
So personal and substantial participation is exercise of decision, approval, disapproval, recommendation, rendering of advice, investigation, or otherwise.
Okay.
Into that case. And so if it's personally, you're directly participating.
Okay, directly. In the middle of it. Okay. But what about substantial?
So whatever you're doing would have to have significance. to
Okay.
The case.
So what about my hypo?
I would say that's not, it's personal, but it's not substantial, because, I mean, a memo is just like,
Yeah, I'm heading out the door. I'm just like, yeah, that's good. I did the research. And I'm thinking about my next step. I've done everything competently and everything, but I have direct involvement, but it is not of significance. You see on page, and that's the difficulty about this rule. We don't have a direct definition, but you see on page 444, we want that direct involvement that is of significance to whatever we're making in terms of decision making. And then that information will be a disadvantage to the client. That's why it says and. So we want the type of information and the involvement to make a determination about whether or not this individual attorney is disqualified. So notice how this rule is set up. 1.11a deals with that, the conflict itself of this individual attorney. And then that attorney can participate if she was not participating directly and substantially, doesn't have access to information that would disadvantage the former government client. If she does, then we ask the government for informed consent. From appropriate government agency. So that's not automatic. The government may say no. And so 1.11b really deals with that. It says, okay, this one lawyer has this conflict, and we know that this conflict moves through the firm. 1.11b deals with imputation. So even though this conflict runs through the firm, there may be something that we can do about it. Imputation for government lawyers. Look at the top of page 445. So that's just a little rule chart that we have in the book all the time. But this rule tells us something a little bit different. What does this rule do? So you know, the first prong of this rule states the imputation rule. And we saw this in rule 1.10. And you recall that the requirement of 1.10 was a lot more stringent here. A lot more stringent than what we have here. And if you look at comment 4 to this entire body of rules, we see that we want to encourage movement back and forth. There's no reason why the government should not have access to the best attorney. Pays less, but that's fine. That's when you hear people in public office say, I'm going back to make some money. That's what they're talking about. I'm leaving this position and I'm going to this other firm. And so the back and forth, we don't want it to be so rigid that conflicts serve as barriers to people pursuing public interest work and on the flip side, private practice just because of the conflict. And so comment 4 really talks about that. But how does 1.11b work? How does it work? So notice, when a lawyer is disqualified from representation under paragraph A, that's what we just did. No lawyer in a firm with which that lawyer is associated may knowingly undertake or continue representation in such a matter unless. I'll just put, for conflict purposes, the firm is one lawyer. The firm cannot represent unless. Unless what? Unless what? Yeah, it's written.
they screen the disqualified lawyer and then also give notice to the government, the appropriate government.
Okay, so notice we're encouraging screening, and it's a lot less stringent than what we had in 1.10. Talk a little bit about the difference between those two, just sort of as a review.
Oh, between 1 and 2, you mean?
Between 1.10 imputation and now what we're doing in the 1.11.
Oh.
Just how more stringent it is. So the imputation gives us the option of screening. Well, what we're talking about now is more specialized because we have that former government lawyer. Here we just have lawyers moving between firms, and it seems a lot more stringent. I'm referring specifically to 1.102, A2. So the prohibition is based on 1.9A or B, so some type of formal conflict, and arises out of the disqualified lawyers association with a prior firm. And so what do you notice that's kind of different about 110?
I mean, they have to give the former, they have to contact the former client and give a lot more information about how the screening was done and the procedures that were in place. And review may be available before tribunals, there's a lot more involved.
Certificates of compliance. And so this is the lawyer just moving to another firm, and there might be impact because of the former representation in 110. And so we're saying we're really concerned about under 1.9a about this materially adverse information, and we're also concerned with the type of information that the lawyer actually acquired. So not only what the lawyer would have acquired in this representation, but actually required. Remember, 1.9a and b made distinctions between those two things. But we're still concerned with the lawyer moving over and having this information. It's less stringent here because we want to ensure that people can move from government to private practice. So we don't have the written notice. We don't have certificates of compliance. And the written notice is fairly detailed if you look at 110. So not as stringent. So here we just need written notice. Let's put disqualified lawyer explain. And written notice. That's it. And I'll put compare. Timely screen. So you have a different standard when we just talk about simple imputation. Here, notice this. The ruling tells you these are special conflicts of interest. So we want to encourage movement by regulating it in some way, but not as stringent as we did under 110. So if you look at the rule that we're working on now, 1.11, you have this disqualified lawyer. We still want to work on the case. The government isn't going to give us any consent. This disqualified lawyer under paragraph A means that no lawyer in our firm can undertake this unless we timely screen from any participation in the matter and no money from the matter. No fee is apportioned. And written notice is given properly to the appropriate government agency. And so we don't have the elaborate framework like we did under simple imputation because the government can take care of itself and the government will make a determination about whether or not compliance is enough in this case. So the first part of the rule sets up the conflict of the individual attorney. The second part says this conflict can move through the firm, but if it does, we can screen. And then 1.11c deals with this special type of information that a government attorney comes into contact with. Confidential government information. What is that? Why is that so important? Confidential government information. You see your little chart on 1.11c on page 446. But look at your rule book too. That breaks it down too. Confidential government information. So we've gone from conflict, how the conflict runs through the firm, to now what type of information you may have had from your prior employment with the government, and whether that can be used in this private matter. So what's the big deal about confidential government information?
It's information that you get under government authority. Usually has some kind of clearance, and then you have privilege not to disclose certain things.
Yeah. And notice this information comes from your special powers as a government official. This isn't circulating publicly, this is non-public information, and it's derived solely from your position. So this is a special type of information. And so we say in 1.11c, the lawyer having information that the lawyer knows is confidential government information about a person acquired when the lawyer was a public officer or employee may not represent a private client whose interests are adverse to that person in a matter in which the information could be used to the material disadvantage of that person. So you're in private practice, you have this government information, you use it against someone because of who you're representing currently in the private matter. You have this government information and you unleash it. So this government information is defined in the rule as information obtained under governmental authority. So this is a special type of information. And it isn't public. The government is either prohibited from disclosing it publicly or there's some type of legal privilege not to disclose. On any level, it is not available to the public. And so notice there's screening provided here too. So the first part of this rule says cannot, on this paragraph, use information so that person is someone whose interests are adverse to the client that you're representing in this current matter. You have governmental information you're trying to use. I'm just paraphrasing the rule. The rule is just make sure you look at the rule. So you cannot use this information for the material advantage of that person whose interests I'll just put to the current private client. So again, you come from government practice, you have this type of confidential governmental information. A clear signal is that it derives from your past opportunities, duties, and obligations as a government lawyer. You come into private practice, you cannot use that information to the disadvantage of that person whose interests are adverse to the current private client. So someone you're representing, you can't use the confidential governmental information that you've obtained against someone on the other side of the deal, or the other side of the transaction. That's just a paraphrase of the rule. So if you have this information, it cannot be used. But notice, what about screening? Is that in the rule too? What about that? This lawyer is disqualified. So is screening permitted even if you have a disqualified lawyer? Yeah, tell me how it works.
Yeah, so they, if, they're part of a firm that's gonna represent my client, then as long as the, disqualified lawyer is screened for the participation in the matter and is no part of the fee,
Uh-huh.
then it's
Good.
good.
Disqualified. Cannot participate in or receive a fee from okay. So we got most of the room down. We have the conflict, we have the imputation, we have the type of information that we don't want used, but we still have screening. Now we have to do 1.11D. Now what is the difference? Well, one last thing I want to say, you don't have to ask permission here. If it's imputed and we have this former government lawyer who has this conflict, if you look on page 445, the firm does not have to seek consent from the government agency as a prerequisite to taking on the conflicted work. That's under 1.1B. That's why we went right into screen. And you'll see in your text that this confidential government information, the government can't give you consent to use that. So that's something that can't be consented to. So that's why we go again to screening there as well. We disqualify in a timely manner the lawyer, screen the disqualified lawyer, and make sure there's no participation, no fee. Yes.
About one thing, what if that confidential information is
A little bit loud, I can't hear you.
What if the confidential information gets leaked by someone other than the lawyer, like say a whistleblower, like reveals that confidential information to the public? What is this still considered confidential for conflict purposes, or?
Well, I don't know. I think I think there's something built into whistleblower statutes that give you a privilege to do that duty. So we don't. You always want somebody to break the privilege if the government is doing something wrong. So you see the current argument we're having back and forth about, it being hearsay, can you report this as an obligation? That's why everyone's talking about a whistleblower being exempt. So this may be confidential governmental information, but it isn't being used to the disadvantage of some client on the other end. It's used for another public purpose of making sure that there isn't corruption. So I think that would be an exception. Yeah. Good. And also that's a good answer. So also. In response to the talking question, you also have to make sure what type of information it is. We've already talked about that, but we have to make sure we're talking about actual knowledge. That's why I have comment up there. So if we're talking about confidential governmental information, we mean a scenario where the lawyer has actual knowledge. It doesn't really work with information that merely may be imputed to the former government lawyer. Actual knowledge. So we want this lawyer to have something that is kind of explosive based upon the prior duties as a government lawyer that can be used to the material disadvantage of a private person in this matter that the former government lawyer is representing a client in. So we have former government lawyer moves to private practice. What about 1.11D? What scenario? This is a different scenario. So look at page 448. We're talking about a different scenario. So how is this different than the situation we were talking about in 1.11A? A little bit louder, can I hear you? Current lawyer, good. Current government lawyer. I'll put that up yourself. Current. So this is someone who's come from private practice and now is a government lawyer. Government lawyer from private. Right. So the former labor secretary, remember Acosta? He was a private lawyer and the dean of a law school, but he moved from that to being a government lawyer. So then you have to analyze what he did in private practice that could impact his practice as a current government lawyer. So notice this, forward and backward again. A lawyer currently serving as a public officer or employee is subject to 1.7 and 1.9. Subject to current conflicts and 1.9 form. And then you have the same language that you had over here. Shall not participate in the matter which. Now here, this next problem that we're about to do measures this. Participated personally and substantially. So we have a number of things to do. We have to look at the current representation, we have to look at the former representation, we have to figure out what matter is. And so we're gonna, we're gonna have to do some substantial relationship. what that means in order to resolve this next problem. Now there is an exception. So like if you were a law clerk or something like that, judicial law clerk, and you're negotiating for private employment, this isn't going to affect you. It even says it in the rules. So that's not where we're more concerned with this government lawyer from private practice and what have you. So subject to 1.7 and 1.9, and shall not participate in a matter in which the lawyer participated personally and substantially while in private practice, unless the appropriate government agency gives informed consent, conformed in writing. So that sort of lines up nicely, I guess, with this problem on page 449. Current government lawyer. District attorney, problem 10.1 on page 449. District attorney. So we're looking at 1.1D, or sections under there. We have to figure out how this works. And so what's going to be interesting about this is, when this government lawyer was a private attorney, he was involved in a civil matter, and now he's a prosecutor, prosecuting this case, criminal matter. Civil matter was an accident. Government matter is a criminal case. That's the current case. And so what's going to drive our analysis on some level is there a substantial relationship between the accident and the murder case? And the facts are sort of set up in such a way as you get always sort of a large lapse of time. We have 12 years past here. 12 years ago, as a private attorney, this district attorney negotiated a settlement for Zeke Brick in an auto accident where he suffered a concussion. So you see on page 449, last month, he's now 17, he was arrested, charged with murder. His lawyer's a public defender. Served notice that, this is going to be important, that the defense is going to be mental disease or defect. In this letter, the public defender goes on, and we're all the prosecutor, tells us that we should disqualify ourselves because 12 years ago, we represented Brick in a civil matter, the automobile accident case. This is on top of page 450. Your old firm has already turned over Brick's case to the public defender, and we haven't asked to receive the copy. And then it just says, under Rule 1.11, should you withdraw from representing the state in the prosecution of Brick, or may we proceed? Can we proceed with this representation? So we're over here. We have a DA serving as a public officer, so we're going to have to look at 1.7, 1.9 in particular, and we cannot participate in a matter in which we participated personally and substantially. But that's seen through the lens of, is there a substantial relationship? And you can start off by saying, well, are these things really substantially related? Yeah, how do we know? How do we make a determination? That's what we're talking about under 1.9. So, you could say car accident, murder, no substantial relationship, that's that. But I think we did something a little bit more critical and nuanced under 1.9. What type of questions did we ask to see if it was substantially related or not? I'm sorry? Well, you gotta look at 1.9. What do we do with 1.9? Significance is over there. And this one plugs you into 1.9 and says, look at that.
Are there materially adverse interests?
Yeah. What type of information? What do we do when we sort of started talking about, even apart from the effect on the former client? We sort of did some evaluation about the quality of this information.
I think it was comment 3 to 1.9 says that substantially related is basically representation of the former matter could have given you confidential information that could be used adversely in the subsequent matter.
That's right. And so notice, that's that presumption we talked about. We're not even talking about actual knowledge. We're talking about if you were an attorney litigating in this particular context, is this the type of information that you would have normally come into contact with? And if so, then we take the next step that Ms. Harper was talking about. Is it materially adverse to the interest of the client? But look at comment 3. It's a presumption. The former client, Brick, doesn't even have to reveal any confidence or anything, because what we're looking at is confidential information that a lawyer normally would obtain in this type of representation. So matters are substantially related for purposes of the rule if they involve the same transaction or legal dispute. That's the easy one. Or if there otherwise is a substantial risk that confidential factual information, as would normally have been obtained in the prior representation, will materially advance the client's position in the subsequent matter. So notice how we tie together what Mr. Manley said about Mr. Manley said and what Ms. Harper said. You connect them both. One is what type of information would you have received, and then what impact would that have on the client? So what do we say about this type of analysis here? What happens here? You know, just in terms of prosecuting, that's going against a former client. No, there's no definition of materially adverse, but there are some cases that say that a former client should have confidence that the former attorney won't undo or come after or show disloyalty to the former client, even though that relationship has ended. So I guess the question after we look at comment 3 is this. Can you use information from the former representation, the civil auto case, to advance the prosecution in the current case?
Essentially, yes.
Okay. Okay, how? What are you thinking about?
I'm thinking about defense.
So when you say yes, you're saying the two matters are substantially related, Mr. Madeleine's point, and then your point, and there is material adversity. That's what you're saying.
Potentially, because I'm thinking about what the public defender is planning on using as his defense.
Okay.
Mental disease or defect. If that were the case, wouldn't you have known something about it when you first met with Rick?
Yeah, and not even actual knowledge though. We're saying if you came into contact with Brick, as you're suggesting, you would have been exposed to medical information of some kind. And so we don't even have to prove actual. And so on some level, you're saying the two matters are substantially related, and there's material adversity. In other words, there is a substantial risk that a lawyer representing a child injured in this case would have learned facts that would materially advance the current prosecution. So all this sensitive medical information, you can sort of just think hypothetically what the now prosecutor would have come in contact in the form of civil representation. You know, brain damage, mental illness, any history of child abuse and trauma, family history of mental illness, criminal behavior, all of those things. There's more. Oh yeah, yeah. So, and I think that should have been pointed out in hypo. I think the prosecutor has, I'll just add some facts to the hypo. I think the prosecutor has told his supervisor, whoever's in office, internally about this 12 years ago, or when it comes to our attention, we disclose it. So yes, the answer is yes. And then the prosecution, to make this hypo go forward, probably said, okay, we know about this, but we're fine with it. Let's go forward. And then the public defender finds out and says, no, this isn't okay. This is a conflict. So, I want to emphasize this. The test is not what the lawyer actually knew, but rather whether a lawyer reasonably could have learned confidential information that could be used adversely to the former client, Brick, in the subsequent prosecution. So, I think what we're pointing at is that there is a wealth of information that can be used to discredit Brick's defense, and that's a problem. That's a problem. So, what do you think happened in the real case, though? This, I think this was from Connecticut, but real case, as most of these cases are. What do you think happened? Do you think the prosecutor was disqualified?
I hope.
You hope? Why?
I think it'd be fair.
I'm sorry?
I think it'd be more fair.
More fair, but why? It has to be more than fairness. Plug into the rule. Why do you think he was disqualified?
Because I think there's a substantial relationship with this, and like you said, he would have potentially have information that could undermine the defense.
Okay, and so that's exactly what happened. The prosecutor was disqualified, and that's fine. They just got another lawyer within the prosecutor's office and went to trial, and the defendant was convicted of murder. But then he appeals, and he says that the entire prosecutor's office should have been disqualified because of this conflict, and the court rejected that argument and upheld the conviction. That's interesting. Good. So that's that first problem, 10-1. And now most PR books are sort of just cover judicial ethics in sort of a basic way, not a major chapter on it, but sort of tries to draw upon conflicts and special conflicts rules and then apply them to another type of government official, judges. So if you look on page 450, you have the canons, but I want to point out that under these canons, there are rules as well. So under these canons, there are rules as well. So the Code of Judicial Conduct is set up for a series of canons, but there are rules under them as well. And so if you look in your book, yeah, start on page 475 or so in your rule book. If this, or towards the end, it's in the appendix. It says judicial conduct materials. You have the different rules under the canon. Now in the book, it's just, in our text, it's just listed as conflicts involving judges, arbiters, and that type of thing. And so we have the first four canons, which are important. Canon 1 is that a judge has to be independent and impartial. So it's not even enough just to say, well, there are no conflicts. You want to avoid even the appearance of impropriety. So this notion of independence and impartiality there should be no question about impartiality. Competence and diligence, that sort of carries over from what an attorney does. Canon 3 says minimize conflict. So a judge has to make sure that he or she is not in a position where conflicts could arise. So maybe the judge used to be a public defender and policy maker for the federal public defenders in D.C. and then moves over to be a judge. And then wants to continue that affiliation with the public defender's research arm. Probably couldn't do that. The appearance of impropriety, notion that decisions will be predetermined, particular ideological bent. So that's why during confirmation hearings or even judicial races, attorneys who want to become judges or candidates for judicial nominees, they have to make sure that there is no appearance of impropriety, no connection with something that could cause one to question their impartiality, and also avoid situations that could lead to conflict. And then finally, no political activity. Now, one thing that's come up, and this has been sort of a major argument in the last 20 years or so, is that all judges are subject to the Code of Judicial Conduct, except the Supreme Court. And so there's this argument about whether or not should the rules of professional responsibility, namely a Code of Judicial Conduct, apply to Supreme Court justices. Some of the arguments is that, well, this is the final forum for resolution of disputes, and we don't need to be policed by any outside entity. It undermines the finality of the institution. The argument on the other side is the judge is a judge, no matter how high, should be subject to the same principles. And so you have that discussion on page 451, and it still goes on. Note particularly footnote 39 on page 452, that discussion. And there would be some uneasiness about the structure of how discipline will work. So if we get all federal judges from different circuits and they sit on a panel judging their peers, what happens to the final decision? Is that reviewable outside of the judiciary? What would be final rule? So those are the arguments. But then on the other side, people say we do it for federal judges. We have impeachment power, or state judges. We have the Kentucky Bar Association Office of Discipline. Same thing throughout all other states. So why shouldn't we be able to do the same thing? Then this other case on page 454 is really devastating case that happened in Pennsylvania. You have these two judges who are pictured on page 455. They basically commodified justice and ran a sort of a juvenile prison mill where they would just sentence people so that we could populate prisons, and they would get kickbacks for that, as well as paving the way for construction of private prisons. And they received over $2.6 million in kickbacks to warehouse juveniles. So in other words, we need people to fill out these new prisons that we're building, and so this became sort of an assembly line, not of justice, but making sure that these prisons were filled. The judges issued about 4,000 juvenile convictions. Those were dismissed, and the judges, C. Varela received 28 years and Conahan 17 years. They're both pictured on page 455. So that's bad. Bad. Now on page 456, you have sort of a list of judges' requirements. And in order not to be biased or prejudiced, you see all of the examples of conduct that could manifest bias or prejudice and what a judge must avoid. So you may recall Judge Sotomayor, when she was doing her confirmation hearings, she resigned from one of her organizations because there's some questions about her impartiality. If she belonged to this private group, and you see on page 457, affiliation with discriminatory organizations undermines the impartiality that a judge has, and so she resigned. Then there is another case that's listed from our own Sixth Circuit. A judge refused to resign from an all-white men's club. And so there is some discussion about whether or not this is just a personal interest of mine. Some judges have argued that in order to avoid not resigning from those organizations. But public interest organizations have challenged that in terms of their impartiality, because the argument goes, if you belong to this group, how can you be impartial? Ex parte communications are generally prohibited, but you see on page 458, there could be an emergency where the judge needs to talk to someone alone. You could have a disinterested expert, so that's not a party, that's fine. A judge can consult her staff. A judge can meet separately if the parties consent to it, or there might be some other situation, other law that might allow it. And so throughout these materials, you see the question is, can the judge's impartiality be questioned? For example, look on page 460, this footnote, this is a hypothetical there. Now, that third bullet point, it says, a judge during the last election campaign to retain a seat said, if elected, I will impose the death penalty on any defendant convicted of first-degree murder. You know, in the heat of a campaign, you make a promise that it's going to get the electorate energized, tough on crime. So in every case that we have first-degree murder, I will impose the death penalty. The judge is elected, and the defendant is convicted of first-degree murder in his courtroom. May the judge hear that matter, or must the judge recuse himself? And so how you do that? So you have these canons, but you also have, under the canons, rules. And one such rule deals with this qualification. This is in the back of the book. 2.11 deals with this qualification. So should this judge be disqualified? So this comes out of the major canon. A judge shall perform the duties of judicial office impartially, competently, and diligently. That's canon 2. And then this rule under canon 2 deals with disqualification. Should that judge disqualify? I just gave you the whole rule, but there is a provision under this canon that suggests that maybe this judge should move on. Look at 2.115. The footnote tells you that too, it's cited in the footnote. But the judge, while a judge or a judicial candidate has made a public statement, other than in a public court proceeding, judicial decision, or opinion, that commits or appears to commit the judge to reach a particular result or rule in a particular way in a proceeding of controversy. And notice how that would undermine impartiality. I mean, you're not judging anything because you already know the result, because you made a promise that you would impose that penalty. So that's not impartial or neutral. You've already made up your decision. So that shows that you're taking a particular position that will impact thousands of cases. So disqualification probably should be warranted there. Let's do this last problem in chapter 10. The judge's professor. This happened really in Arkansas. And so this problem tries to get at ex parte communications, previous relationships, anything that could call into question the judge's impartiality, diligence, and competence. So we are a lawyer for this client. The suit is filed in federal court, and we are assigned to a federal judge, Mindy Lynch. We represent our client. The client used to be a law professor, and now we're in front of this judge who used to be a student. And there was some controversy years ago about a mislaid exam book. And this judge took our client's class, and he doesn't know what happened, but he mislaid the stack of exam books. There was some turmoil in the law school. He lost the grades and offered to give everyone in the class a B+ grade, but she said, no, I feel I deserve a high grade. After some negotiation, he gives the then student an A. So that's one. Then there's another funny coincidence as well. The judge's husband is now a law professor at the same law school where our client used to work. They know each other just a little bit. And even weirder says the lawyers went to meet with the judge for a status conference a couple of weeks ago, and the husband is in the pretrial conference, participating in the discussion of the issues in the case. And there are rumors that the judge's husband helps her from time to time evaluating the side cases before her. So that's bad. So the question goes through a couple things. First is, what impact does this prior relationship between Lynch and our client, the judge and our client, have on this case? So should we sort of disclose this and deal with it? Assuming that the ABA Code of Judicial Conduct applies, is a motion requesting recusal is filed, will the judge have to disqualify herself? We look at 2.11. Then finally, the Code of Judicial Conduct prohibits a judge from allowing family, political, financial, or other interests to influence the judge's independence or conduct. Now, 2.9 allows the judge to receive information and consultation from a disinterested expert, but can we look at her husband that way? And then the question is, has the judge violated the standard of judicial ethics? What do you think? So when we come back, I want you to look at Rule 2.4, 2.9 of the Judicial Code. Did the judge violate these rules? And then we're going to look generally at 2.11, should she disqualify herself? And that will finish Chapter 10, and we'll start Chapter 11 when we come back on Tuesday. Have a good week. The revolving door, and that was Chapter 10, conflicts, issues for government and judges. And we went through that chapter. That's the last chapter on conflict. And then the next one, Chapter 11, we're going to do something today, talks about our duties to outside entities. Primarily in Chapter 11, our obligations as officers of the court. And we've seen this moving through the decisions in our discussions. We talked a little bit about Canada Courts Tribunal. We know that we're officers of the court. We even talked about it as an underlying issue when we have 1.6, confidentiality. Certainly confidentiality means that we preserve client confidences. And we saw how broad that duty was. It lasts even after the attorney-client relationship has been terminated. And so it's very important. But there are exceptions. And we're going to see today, it may come a time where we have to reveal a confidence to keep from presenting perjured testimony or false testimony. We see a case a little bit later on, Nix versus Whiteside, that says there is no constitutional right of a criminal defendant to present perjured testimony. Now, you defend your criminal client vigorously. You make the prosecution prove each and every element of their case beyond reasonable doubt. You may even advance a defense that you don't believe in if there is a good faith basis for advancing that defense. But you cannot present perjured testimony. So we'll see some of that today. Now, before we even get there, we, in our last chapter, was looking at these duties that government attorneys have. And we focused primarily on the four rules up on the board. 1.11a really talks about the conflict where you have a former government lawyer moving to private practice. And we talked about how former representation is a part of that analysis. 1.9c, you know that we can't use information from the previous representation in order to disadvantage and detriment of that former client. So we know that we're subject to that. And then we shall not represent a client in connection with a matter, that to figure that out, in which that lawyer participated personally and substantially as a public officer. So when he was a government officer, participated in this matter, we have to define what matter is. That could be a proceeding, that could be research, it could be any number of things. Personally participated substantially as a public officer. We know that this rule is designed to allow movement between government to private and private to government. We don't want it to be so insurmountable that we undermine the fluidity of the legal profession. We don't want to impact a client's ability to have the attorney of their choice. So we talked about that. And then we said, if we find that the person participated personally and substantially. So this is going to be fact specific. Maybe you were a government lawyer and you reviewed a couple of research memos and offered your opinion in one paragraph in an email. And then you are moved from government to private practice. And the matter may be related, but we want you to be personally and substantially involved. And if you have not been, then you can work on that issue. Now, if you have been personally and substantially, you were responsible for this case as a government officer. You saw it through from research to pleadings to proposing legislation and all of that. You are personally and substantially involved in that matter and cannot do anything in the private sector unless the government gives informed consent. So 1.11a really defines the conflict. It tells us if you are a government officer, you move from private practice, you may have a conflict because of the former representation. We want you to be careful. 1.9c, which talks about using whatever you have in a private representation against that client, unless the government gives informed consent. Now, the government may not give informed consent, and then we move up here. This is a theory of imputation. We're still talking about that former government lawyer moving into private practice, but that lawyer has a conflict. Conflict moves through the firm. And so we say, okay, that is a conflict that moves through the firm, but that former lawyer is precluded from handling that matter. Okay, we just make sure that that lawyer does not become involved in this new matter. Timely screen, written notice to the appropriate governmental agency. We don't have to seek consent from the government agency as a prerequisite to take on this conflicting work. And there's no detailed information about screening like we talked about earlier with imputation. That's on page 445. Again, we talked about confidential governmental information. That is non-public information that is derived from your former participation as a government official. if a former government lawyer has actually learned, look at comment A, information about a person that was obtained under government authority, and that could be used to the material disadvantage of that person in a new representation, the former government employee cannot take on that work. And that really cannot be cured by consent, because you'd actually be asking the government to allow you to use this special type of information against someone in the current representation, and that would be certainly unethical. The disqualified lawyer, again, can be timely screened from any participation in the matter and no fee. So screening is permitted here as well. And then in this last category we talked about, that is where you have a current government lawyer who has moved from private practice. And we talked about former client conflicts. So notice this, the current government lawyer is subject to 1.7 current conflicts and former conflicts and shall not participate in the matter in which the lawyer participated personally and substantially the same thing while in private practice. So we look at all of those as scenarios when the lawyer moves from public to private and private to public. Now, we also look at judges, look at those ethical canons and discuss those. And I think the last thing that we had to do was, did we do the judge's former professor? On page 466? Probably not. We did, okay. But before that we did the VA, problem 10-1, and we looked at that and just went through the two cases substantially related, and we came to the conclusion that there is a substantial risk that the lawyer representing a child injured in an accident would have learned facts that would materially advance the current prosecution. You know, things like brain damage, mental illness, history of child abuse. So we noted there that the test is not actually what the lawyer knew, but whether the lawyer might reasonably come into this type of confidential information that could be adversely used to the former client. That would be brick in the subsequent representation as prosecution. And there is evidence that could be used to discredit Brick's defense. And we noted that in the real case, the prosecutor was disqualified. That was problem 10-1 that we did. So, 10-1 was on page 449. So now we're doing 466, the judge's former professor. Now this actually happened, this you may not know, this is a former President Clinton and a federal judge in Arkansas. So, you know what ultimately happened, but then the question in this case is whether or not the judge should be disqualified. So we looked at, in doing this problem, we looked at the judicial canons, starting on page 450. So you need independence and impartiality, competence and diligence, should minimize any conflicts and all those things. Now each of those canons have individual rules under them. And so the individual rule that we're looking at in connection with the judge's former professor is rule 2.11. Now that's in the Code of Judicial Ethics. That's towards the back of your book. It talks about disqualification. So we're going to use this rule to look at and the question is, should this judge be disqualified? And you get this, a judge shall disqualify himself or herself in any proceeding in which the judge's impartiality might reasonably be questioned. And then we have these different circumstances set out in the rule. And you have that on the top of page 467. Prohibits a judge from allowing family, social, political, financial, or other interests or relationships to influence the judge's judicial conduct, That's 2.4. And then you also see rule 2.9. I'll put family ties here. Disinterested expert here. And 2.1 is talking about this one. So, has Judge Lynch violated either of these rules? If so, should you object on behalf of your client to Mr. Lynch's involvement? Review the relevant rules before you answer this question. So you got the facts on page 466. There's some prior relationship with this judge. The major thing is that Judge Lynch's husband participates in ruling on motions and discusses that with his judge. There are rumors that Mr. Lynch helps his wife to evaluate and decide cases before her. So, should the judge recuse herself? Should we advance this motion? What do we do here? If the plaintiff's lawyer does not file such a motion, should we do so? What about this? Is this ground for recusal? Or better yet, if you were the judge and the attorney in this case, would you try to advance a motion for recusal, or would you leave it alone? What would you do? These rules are way in the back in the canons. So 2.4 deals with external influences on judicial conduct, and 2.9 talks about the court being able to engage disinterested experts. So what do we do here? Would you file a motion to recuse this judge? Yeah, there's more. Go ahead.
Yes, because under the publication rule 211, it says that the judge shall disqualify himself or herself in any proceeding in which impartiality might be reasonably questioned.
Okay, so the judge would have to do that, right?
Right.
Okay, so that's interesting. So this, you notice in the readings, it comes after this whole discussion about Supreme Court justices not being subject to the code of ethics. And sometimes there are cases, like the most notable was a case where the court was going to rule on an environmental protection agency or something, and Justice Scalia had gone on a hunting trip with then Secretary of Defense, I think Cheney, and then Vice President Cheney, and then I think that he was involved in this EPA commission. And the question was that a conflict of interest? Does that undermine impartiality? And Supreme Court justices have always argued that this is a court of last resort, and we don't have to recuse ourselves, unlike other federal judges or state judges or anything. So this rule is sort of drafted so that a judge will see this disqualification, and the judge will disqualify himself or herself. So that's sort of like the judge taking initiative. Now, if the judge doesn't do it, you have to do it. Let's say that the judge doesn't do it. She didn't in this case. Now what? Should you move to recuse the judge? I think certainly if we read the rule the way it is, there is a ground to question this judge's impartiality. There's just even the rumors that are circulating around in the legal community that her husband may help with motions, that there is this prior relationship, all of these things. So nothing much happened in this case. In real life, the judge did not recuse herself and went on to rule on President Clinton's misconduct. Remember, he took the deposition and he was being questioned. He said it all depends on what is, and that was sort of a misrepresentation. Then his lawyer has to report that to the federal judge. This federal judge was Susan Wright Weber, and then she moved on that, and then that's what really ultimately led to President Clinton's disbarment. I think he's since been reinstated, but that is what caused him to be disbarred. So in this case, I think the judge would have to do it, and then you have to make a strategic decision about whether or not you move to recuse. There are upsides and downsides, and on these facts, there are facts that sort of look at impartiality, but the second question is, should you file it just because you can? And in this case, in real life, the judge stayed on the case and ultimately ruled on Clinton's misconduct. Now, the only other thing in this chapter is conflict rules for former judge, law clerks, arbitrators. So a lawyer cannot represent in a matter in which she participated personally and substantially as a judge. So that's a judge moving to private practice can't do that in terms of representation. And then finally, there is room for you. Look at page 469. As a law clerk, you can negotiate for employment with full disclosure, because notice we recognize that you'll probably be moving from that 1-year clerkship or 2-year clerkship into private employment. So your law clerk on the 6th Circuit, open disclosure to your judge and anyone else that you are negotiating to go with the public defender or a firm here in town, White Aaron Combs, that's fine. You see it on the top of page 469. A lawyer serving as a law clerk to a judge or other adjudicative officers may negotiate for employment. So that's all of the conflicts. So current conflicts, former conflicts, special conflicts, and then conflicts when a government lawyer moves to private practice, and a former lawyer moves to private practice, and a government lawyer moves from private practice. The revolving door. And now we're looking at another form of conflict, because it may form a conflict with our client because of our overarching duty as officers of the court. So if you look at chapter 11 of 471, lawyers' duties to the courts. So notice, over and over again, the theme of this course has been that we represent a client, we have undivided loyalty, we have confidentiality concerns under 1.6, we have all of those things, but we have to balance those with the rules of professional responsibility, and the other law, and then external obligations that we have. And our most primary one is as officer of the court. So, what about this? This is interesting. This chapter starts off with the traditional discussion about what type of lawyer are we? Are we hired guns or are we officers of the court? In other words, this sets up this tension between higher principle lawyering and hired gun. In other words, advocating for a particular viewpoint at all costs. You see that on page 473. So there's this discussion of client-centered lawyers. In other words, we advance the client's claims at all costs, even if that means some compromises on our higher duty as officer of the court. So you see this discussion on page 474. Stephen Gillis, can a lawyer be a bad person? And so I want you to sort of unpack these two hypothetical examples here. Very interesting. The first one is the one designed to evoke sympathy to you as an attorney. We have first a man whose lifelong dream has been to open a fancy restaurant. He persuades a wealthy cousin to give him $50,000, but the man who wants to open the restaurant isn't totally sophisticated in business affairs, and the rich cousin who loans him the money is. As you can imagine, the restaurant takes off and is hot, and the man who has signed a note for the loan opens this restaurant. Food critics give it rave reviews. Then the cousin, who's the sophisticated one, comes in and demands payment of the loan, hoping to push his cousin out and take over the restaurant. The man goes to a lawyer, and notice this. So the whole issue is whether or not the lawyer can advance formal technical motions in order to protect the client and buy time. Maybe the client will be able to find the money from a bank. Maybe the restaurant will stay in existence long enough so that the receipts that are coming in will help him pay off this $50,000. So we're representing this client who has sort of been taken advantage of by a wealthy cousin, and we are making non-frivolous motions to buy time. Is that okay? So notice the type of motions that we're bringing. For example, one motion points out that the law requires process servers to be 18. The process server in this case was 17 years old and 11 months or something. But we make that motion just to keep it. Is that appropriate? So before you answer that, look at the other hypothetical on page 473. Same type of formal technical motions to buy time, but this scenario is constructed to contrast with our representation of the good client. Now we're representing a quote bad client. We represent a construction company. And so we're trying to use formal technical motion practice in order to force settlement of the case. We just keep it going. We know the other side doesn't have money, so we just dump all the documents on them. There'll be document production. Every motion that we can press, we will. You know, everything to, this is the wrong type of margins in your pleadings, to time limitations, all of those things perfectly within the rules. And we're doing the same thing that we did for the good client. What about that? And so on the bottom of page 475, it says, question about being a good person. Do you expect to use such tactics? If your answer is yes, do you expect to have any moral qualms about doing so? You know, that's a question that gets at practice, the morality and practice, but more importantly, should we be really relativist when we talk about morality? In other words, when we're doing it for the good client, that's great, but when we're doing it for the bad client, we should feel cheesy about it. What about that? How and when should you use these formalistic techniques to advance your client's claim? And does it depend on who the client is? What about that? Can a good lawyer be a bad person? What about that? Talk, go ahead.
I think it's situationally dependent. In one case.
Situationally dependent. Tell us what you mean by that.
Well,
Because that could be dangerous, so I want you to go ahead.
It can be dangerous, but it's morality itself is not a simple topic. There are many different moral theories on Plato, Aristotle. But for example, with the situation with the restaurant owner, he did get taken advantage of, and he's trying to pay back his loan, but he needs more time to do it. That's not.
See, I feel good about that one. That's okay.
Because it's not necessarily like a sort of like I guess danger or extreme advantage to anybody else. But in the other situation, you're trying to force people who have been taken advantage of by your client, and you know they've been taken advantage of by client to settle. It's.
But you represent the client in both instances, so how do you make those distinctions? Yeah, go ahead. I mean, we can pick and choose our clients. There's some people we may not want to associate with, but in these hypotheticals, we made the choice to represent, and that comes with some consequences. So we feel good about the restaurant hypo, but what about how do we understand and say that we're still representing a client that deserves representation, even if we have to do this? Are we still on the same moral ground that we are when we help the person who's been taken advantage of?
Honestly, to me, it boils down to what your view of morality is.
Yeah.
For example, if you were a subscriber to Kant's ethical principles, then you would be extremely moral because in his view there is, for example, it's always morally wrong to lie.
Yeah.
But as we've seen from the rules of professional conduct, there are situations where you technically have to lie in order to preserve client confidentiality.
Or not affirmatively undermine your client's position. Yeah, that's true. But see, this one. So we're in the classroom. We can have these like conversations of the great philosophers. But when things are moving in real life, and you have these two clients, how will you keep these two things moving? If in one instance you're being good, and in the other instance you're being bad, is there something that unifies those two approaches? So you're a firm, you represent both clients. Yeah, go ahead.
I was saying, anybody, you're protecting your client's interest, so it has to be mutually obvious
Uh-huh.
at the end of the day. So when you sign that into something, you may not be friendly, if you will.
Yeah.
That's John.
Yeah. And that's what advocacy is. And so on some level, it's not good or bad. It's using these rules effectively. And notice how that leads to our discussion of Rule 3.1. Can someone tell me about 3.1? Investigation before. So notice this brings together CivPro. What you did in CivPro and now. So I guess this is what you talked about, the well-pleaded complaint. This is Rule 3.1, meritorious claims and contentions. So this is from our role as an advocate. What does 3.1 tell us? So it says something like this. Investigation before filing a complaint. That's on the bottom of page 475, and then it moves us over into meritorious claims and contentions. This is one of our duties to the court, and it sort of incorporates all the things that we'll be doing in candor when we look at Rule 3.3. But notice this. Lawyers shall not bring or defend a proceeding or assert or controvert an issue therein unless there is a basis in law and fact for doing so. Now, just the most important thing in here is unless there is a basis in law and fact for doing so that is not frivolous. So how do we know something is frivolous or not? Yeah, go ahead.
Whether or not you think you can actually make a good faith argument to support whatever claim you're asserting.
Okay, that's good. So how do you know when that is? Which includes a good faith argument. So something that's not frivolous is you have a good faith argument for extension, modification, reversal of an existing law. And you have to be able to support that. Some basis in law and fact for advancing this claim is not frivolous. It includes a good faith argument for extension, modification, or reversal of existing law. So that does not mean whether you'll win or lose or whether you'll be successful. It's can you advance this argument and can you support it? If you look at in determining the proper scope of advocacy, account must be taken of the law's ambiguities and potential for change. So the lawyer can advance inventive arguments or first-time novel arguments as long as there is a good faith basis and long fact for doing so, not frivolous. That's comment 1. Now, look at Rule 3.1. It seems to make a distinction for a lawyer for a defendant in a criminal case. What's the difference there? Well, why are we emphasizing criminal cases in 3.1? A lawyer for a defendant in a criminal proceeding or the respondent in a proceeding that could result in incarceration may nevertheless so defend the proceeding as to require that every element of the case be established. What's that distinction in there? Because notice the rule tells us what is not, doesn't give us a definition of what frivolous is, but if you look at comment 2, it says that discovery will help us as well. So you don't have to just wait and say, well, I need to really substantiate this. Comment 2 says the filing of an action or defense or similar action taken for a client is not frivolous, merely because the facts have not first been fully substantiated. So that takes into account that the lawyer will make arguments and that they will develop through discovery. Motion practice will begin to corroborate and substantiate our claims. That's going to become important when we look at the first problem here. So lawyers have to inform themselves about the facts of their client's cases, applicable law, and then determine what type of good faith arguments can be made. So you're looking at the law goes against your client, and you say, oh, but there's some things in the Sixth Circuit that are ambiguous. And maybe those gaps in the law is what will form our argument. So we do some more research and we say, oh, yeah, maybe we have a claim, and then we go through discovery. And then, oh, yeah, we're able to substantiate that. So it's not winning or losing. It is, can a good faith argument be made? After we familiarize ourselves with the facts, we do some research, we substantiate this through motion practice. The action is frivolous, however, if the lawyer is unable to make a good faith argument on the merits of the action taken, or to support the action taken by a good faith argument for extension, modification, or reversal of existing law. So if you can't come up with a good faith argument that's substantiated by something, that is going to be clear evidence of a frivolous action. You'll be open to discipline for that. Now, I think the criminal sentence in 3.1 is different because it's saying that so much is at stake in a criminal trial, that liberty and possibility of incarceration, Fifth Amendment, Sixth Amendment, that the criminal defense attorney is free to put the prosecution to their proof. You know, in any number of ways, so long as you're not offering perjured testimony. And so on these next pages, you have this notion that 3.1 also overlaps with Rule 11 in civil procedure. And starting on page 477, parties' legal theory must be warranted by existing law or by a non-frivolous argument. Same thing in 3.1. You're making a good faith argument for modification, reversal, or extension of the law. And so we want some support for these theories that we are advancing. Notice at the bottom of page 477, there's no definitive answer about how to interpret 3.1 and Federal Rules of Procedure 11. Most of these type of discussions have been fact-specific court decisions. So we can't really generalize it, but notice on page 478 to 479, there are some things that the attorney has to do in order to meet her obligation under Rule 3.1 and Rule 11. So you have to make sure that you analyze the facts to make sure that the suit has some grounding. You have to make sure that you're getting the correct facts. You have to make sure that there's some investigation, and you understand the standard of any type of action or motion that you are trying to advance. And so the question often is, should the lawyer trust the client? Certainly, but there has to be some level of skepticism in terms of evaluating the claims that you're trying to advance on behalf of the client. On page 480, there's a comparison between Rule 3.1, where you'd be subject to disciplinary action if you violated the rule, and Rule 11, where the judge has the power to punish monetary sanction or non-monetary directives. And there's a safe harbor provision in Rule 11, but not 3.1. So even though you see in there, even though 3.1 doesn't have a safe harbor provision, it's common practice to say, well, if you withdraw this within an appropriate time, you're not going to be subject to discipline. That's on page 480. So having said all of that, you see on page 482 our first problem, Paula Jones. Problem 11.1. So the reason this problem is in the book is sort of high stakes. You're thinking this would be a garden variety sexual harassment case if the president was not involved. But the president is involved, and this was during the time he was governor of Arkansas. Paula Jones claims sexual harassment and assault. And so how would a reasonable lawyer go about checking out this story in order to comply with 3.1? And it says that the fact pattern is asking you to act as if nothing, you don't know anything else. There's no Monica Lewinsky trial, there's nothing like that. That will come later, and you're just evaluating these facts. And this is from the Federal Reporter, Eastern District of Arkansas, 1994. So what, if anything, do we need to do to corroborate Paula Jones' allegations before we sue the president? Look at comment 2 to Rule 3.1 and see if that gives you any help in terms of what you should be doing in terms of corroboration. So what this is illustrating is, one way to determine if something is frivolous or not is you ask yourself this question as a lawyer: can it be corroborated? So if you look at 3.1 and Federal Rule of Civil Procedure 11, they're both saying we want something that's non-frivolous. They're both saying on some level we need some evidentiary support. So how would you go about doing this? And you shouldn't just be saying, well, this is the president, so I can't. So how would you go about approaching it? In answering this question, assume that a jury could infer from these facts and prove that the president committed the tort of sexual harassment. Also assume that the president is not constitutionally immune from being sued for unofficial acts. So how would we corroborate this? So one way to do that is to look at these facts, then figure out who we would talk to or what we would need to see in order to corroborate our client's claim. So how would you approach this? Is there some things that we should consider? What do the facts tell us? One thing, look at who we should talk to, Mr. Madden.
The only other person we think, besides Paul Jones and the governor, at the time, the facts mentioned is the bodyguard.
Mhm.
I would be hesitant to go straight to the bodyguard
Mhm.
and substantiate that. But you could look, there were other people at the registration desk or other hotel employees who may not, maybe more disinterested than the bodyguard would be to see if they saw her in the room or going to the room or something like that.
That's right. Anything else? So if I don't want to start with the bodyguard, but we can work around people who may have been there to try and find out. Mrs. Harper?
Is it possible to try and get like security camera footage?
Yeah, but let's say it's 1994 though. We're not that. It's sort of, yeah, there's security cameras, but they're not working properly. But that would, if it did, that would be good. Anything else though in terms of people, documents?
Oh, sorry,
Yeah.
if you saw that piece of paper, that would be
Mhm.
good.
Good. Yeah. Good.
There's claiming that they abolished this position, but it's not abolished. That was some sort of paper trail of communication between these individuals higher up to show that, like, hey, we're going to blackball this person.
Yeah.
But you didn't.
Yeah, that's good. That's good. But I think all of you are illustrating. It's not really clear what a reasonable lawyer would do to check out Jones's story, but those are several things that should be considered. Probably not the bodyguard. The bodyguard is close to the president, but we could work our way up to the bodyguard. And if we did have that discussion with the bodyguard, it would be based upon other things that we found, and then we say, is this true? Like the documents about the position, any other witnesses who could be, as Mr. Manley said, disinterested in quotation marks, any factual eyewitnesses. But it's not really clear how we would check this out. But the first thing we'd have to do is to analyze the claim that she wants to bring. And we note in the fact pattern that if we prove those, then we can establish that the president committed the tort of sexual harassment. We have our client's factual interpretation of what happened, her factual narrative, and all we need to do at this early stage is to corroborate that. And so comment 2 sort of gives us some help in doing that. And I think as long as we had a good faith basis for advancing this claim, it wouldn't be frivolous and we can move forward. Truth and falsity in litigation on page 483. Someone take me through Rule 3.3 is fairly candor towards the tribunal. This is explicit recognition of our duties as officers of the court. And you have the chart on page 483, but so this rule does basically 3 things. It tells us that we shall not introduce a false statement of law to the tribunal. It tells us that as part of that duty, this is a separate section, we shall not fail to disclose adverse authority in a controlling jurisdiction. So we are in Western District, Kentucky, and we're litigating a securities case. And opposing counsel does not cite a case that goes squarely against us that everyone knows about, against some sloppy lawyering. Opposing counsel has not brought that to the court's attention. You have to bring that to the court's attention. And that's not so devastating. You will have known and thought about how to distinguish this anyway. But you must affirmatively disclose directly adverse authority in a controlling jurisdiction. That's 3.3A2. So it starts off 3.3A1 by saying you shall not knowingly make a false statement of fact or law to a tribunal, or fail to correct it, statement of material fact. So notice that's affirmatively you cannot present this false statement of law or fact, and if you know about it, you have to correct it. 3.3A2 says you cannot fail to disclose a adverse authority in a controlling jurisdiction. 3.3A3 says you cannot offer evidence that you know is false. You have to know that it's false. Now notice how that gives you a little bit of room as an attorney. You cannot knowingly present false information. Now, on some level that does not mean willful ignorance because knowledge can be inferred from the facts. But 3.3A says you cannot offer evidence that you know to be false. So what happens if you have a witness on the stand and everything's going fine, and then you realize, and the trial is still going on, you realize that your client has presented false testimony? What does this rule tell you? Because notice, you've offered that false testimony in the form of your client. So what does 3.3 tell you have to do? Yeah, go ahead.
You have to correct it.
Correct. Yeah, how do you go about doing that though? So, yeah, how would you go about doing that?
So I guess you would have to affirmatively disclose. That's actually never wrong. But I guess that you have to like affirmatively address that you had done like you can't just do that.
Okay. So notice this. Shall not knowingly offer evidence that the lawyer knows to be false. And if we come to know of it, that we've offered material evidence and the lawyer comes to know of its falsity, the lawyer shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. So what does that mean, reasonable remedial measures? Seems like we're always qualifying our duty. Yeah, what does reasonable remedial measures mean? So we shall not knowingly make a false statement. And I'll just put here, I'll just put must correct the false statement. So we can actively do it, and if we make a mistake, we have to correct it. Shall not fail to disclose, just paraphrasing the rule, adverse authority in a controlling jurisdiction. Or offer evidence that the lawyer knows, have to know. And if the lawyer comes to know, the lawyer shall take reasonable remedial measures. So do we have a clue about what these reasonable remedial measures are in case we have inadvertently presented false testimony? Yeah.
So, I mean, it says like you should counsel your client to correct the record.
Yeah.
But, I mean, I'm just thinking, if you're going to directly question your own client in a trial, can you just correct the record then?
Well, your client has to have input, so you're not going to like turn on your client. The first step in the way the rule is done is we have to tell the client, I'm an officer of the court, we can't present perjured testimony, you really should change this, I hope that you correct it. Client says no, then you say, well, now I have a duty to disclose, even though this may be 1.6. So the rule is sort of designed so that you'll sort of use your leverage on the client to correct. Look at comment 10, it sort of answers this. So comment 10 talks about these remedial measures. And so not a real direct answer, because these are fact specific. Look at comment 10, and it says this. Having offered material evidence in the belief that it's true, we subsequently come to know that the evidence is false. The lawyer must take reasonable remedial measures. So this is what I was talking about. In such situations, the advocate's proper course is to remonstrate with the client confidentially. Take the client aside, look, I know that you presented false testimony. I'm not turning against you, but I have a duty as an officer of the court that I have to balance with my advocacy role for you. And advise the client of the lawyer's duty of candor to the tribunal and seek the client's cooperation with respect to withdrawal or correction of the false statements or evidence. So we want the client to do that because on some level, if we have to go further, we will be turning against our client. So we want that united front where we say we made a mistake, the client is going to withdraw, my client is going to withdraw his testimony, we want to correct it. So notice how this runs through the rule. If we make the mistake, we certainly have to correct it. If we come to know of our client doing it, we want to tell our client we need to make this correction, and hopefully the client will do it. Because we say, I'm balancing these two things. My higher calling on some level is as officer of the court, and I'm not going to jeopardize my professional reputation or expose myself to discipline by offering perjured testimony, which I shall not do. So notice it goes further. If this fails, and my persuasive argument to my client to correct this, if this fails, the advocate must take further remedial action. And maybe you withdraw and say, no, I'm not presenting that, but then the rule goes on. If withdrawal from the representation is not permitted, or will not undo the effect of the false evidence, the advocate must make such disclosure to the tribunal as reasonably necessary to remedy the situation. Now notice that limitation. That doesn't mean that you dump every confidential thing under 1.6. You do exactly what is necessary to remedy the situation. We want an appropriate correction. Notice this, even if doing so requires the lawyer to reveal information that otherwise would be protected under Rule 1.6. Revelation may be appropriate. And I say may because this is the second step after you try and convince your client. Revelation may be appropriate, notwithstanding 1.6. So this is a long-winded way of saying we don't want to correct that ourselves going against our client. We want our client to correct it on the record, and then we move forward from there. So that's A, 1, 2, and 3. What about letter B? So this is, up to here, these are mistakes. But letter B deals with a situation where the lawyer knows. Engage in criminal fraudulent. So up until this point, it's been fairly inadvertent, but look at this. A lawyer who represents a client in an adjudicative proceeding, and he knows, or she knows, that that person intends to engage in criminal or fraudulent conduct related to that proceeding. She'll take reasonable remedial measures again, including disclosure to the tribunal. If necessary. So our first step isn't just blanket disclosure. We try and deal with our client first, and then if that doesn't work, disclosure. 3.3c says the duty stated in A and B continue to the conclusion of the proceeding. So if we know about it and we correct it, or we didn't know about it and we later find out about it, there's a duty to correct. Continue to the conclusion of the proceeding, and apply even if compliance requires disclosure of information protected by 1.6. So we see this whole thing, on some level, is an exception to Rule 1.6. I'll put exception to Rule 1.6 when necessary. And then letter D just says, in an ex parte proceeding, a lawyer shall inform the tribunal of all material facts known to the lawyer that will enable the tribunal to make an informed decision, whether or not the facts are adverse. So notice that's sort of a continuation of the duty to disclose adverse authority in a controlling jurisdiction. If you are in an in an ex parte proceeding with the judge, you are alone, and if the things that go against you, you have to disclose that to the judge as well. So all of these things are sort of our duty as officer of the court. Another thing that the book does is it points out some rules that we have been cross-referencing all along. Remember, we did a case called Reese's Pieces. We talked about Rule 4.1 and how 1.6 may seem permissive, but if we are helping the client engage in fraudulent or criminal conduct, disclosure becomes mandatory. So if you look in the book on page 485, we have these rules that sort of overlap with each other. We have the rule of candor that we have been talking about, but we also have rules like 4.1, truthfulness and statements to others. So notice all of these are duties outside of the attorney-client relationship that may impact their representation. So we are officers of the court, cannot present perjured testimony. Notice the perjured testimony might even help the client, and the client may want you to do that, but we cannot do that because it's false testimony. So truthfulness and statements to others, and then you see the big 8.4, all of you are familiar with this, misconduct. We cannot engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. So notice that is a blanket prohibition that comes into everything, because notice in the box, in the discussion of Rule 8.4, that it applies to all conduct. So anything that we see that could be dishonest, that's 8.4, so catch all, 8.4c, top of page 45. So 487, you see Nix versus Whiteside, it's a Sixth Amendment decision. Doesn't arise under the ethical rules, but it gives us this basic proposition. So if you have a criminal defendant and the criminal defendant says, I want to testify, we have to do it this way. The only way I can get off is if I offer perjured testimony. The attorney doesn't do that, and then the client on appeal says, well, that's ineffective assistance of counsel. We had an argument that we could make, and even though that argument sounds in perjury, the lawyer should have advanced that claim. Nix versus Whiteside said, whatever the scope of a constitutional right to testify, it's elementary that such a right does not extend to testifying falsely. So there's no breach of professional duty when the lawyer refuses to present perjured testimony. You see that on the bottom page of 487. So let's set up this next problem. This is 11.2, flight from Sudan, scene 1. So the first scene makes us sort of look at and evaluate our client's claim. And then following up on that, we probably won't get to the second today. Following up on that is we accept our client's representations, we resolve them in favor of our client, which we can do, and we decide to move forward. But this first problem on page 489 is sort of a preliminary discussion. So this is Flight from Sudan, scene 1. And so we represent a political dissident, and we're trying to figure out whether or not that dissident will be deported. So we are a staff lawyer at the Immigrants' Rights Center. We represent Joseph Baragabi. He's an applicant for political asylum. You see on page 490, we're really concerned about his emotional state, and we think that things are so repressive in Sudan that if he was deported and he loses the appeal, he might commit suicide rather than return home. So there's a brutal dictatorship in Sudan that represses all political activism and speech, and Baragabi claims that he was a staff member and columnist for a newspaper called Democracy. So notice that this is going to be set up in a way that we have to corroborate what our client is telling us. It's going to give us some work on Rule 3.1. So 6 years ago in April, the government raided and closed the newspaper, arrested several of the editors. Baragabi escapes, he leaves with his family, comes to New York, but he gets to New York with a counterfeit passport. As soon as he gets to the United States, he tells authorities that he has his counterfeit passport, requests asylum, and as a result, he's automatically placed in deportation proceedings. So that's where we are. The standard, and remember I said you have to know what standard that we're trying to corroborate? The standard in a deportation hearing is a well-founded fear of political or religious persecution in his home country. So I can't go back there because if I do, I will be subject to jail or even worse because of my political or religious beliefs. So if our client is unable to meet the standard of well-founded fear of political or religious persecution, our client will be deported. So it's important for us to corroborate our client's story. Not a great success record in these proceedings. Only about 1/3 of asylum applicants are successful. And so notice this is the key. On page 490, only about 1/3 of asylum applicants are successful. A major barrier to victory is corroborating evidence. So we need either documents or testimony for other witnesses to substantiate our client Baragabi's story. So it's really easy to corroborate the context. We know what's going on in Sudan. We know about this newspaper. But what is missing, you see this on page 491, is we cannot document whether or not our client has actually worked for this newspaper. Did Baragabi ever work for this newspaper? So we want to prepare a detailed affidavit, a sworn statement that our client will sign and file in court, telling the whole story. Under court rules, this affidavit is due in our next class, Thursday. So in the hearing in 2 weeks, we're expected to testify consistently with this affidavit, and we have been searching for corroboration of his employment with the newspaper. We can't find any of the editors or people who work in the newsroom. We get a lucky break, and we find the editor of the newspaper, Democracy, Mr. El Parra, but he does not recall our client. We're really surprised about that. He says, I never heard of Baragabi. I know everyone who works here. We describe our client's appearance, and Mr. El Parra insists that he knows all of the employees, and Mr. Baragabi is not one of them. So we have a series of questions. Should we tell Baragabi about our conversation with El Parra? Should we file the affidavit? Should we ask the court for permission to withdraw from representing Baragabi? We have to make a decision. Is it too early to do that? Did we violate Rule 1.6 by contacting El Parra? And then finally, did we do our job too well by finding out all of this information? So we're going to pick up with those 5 questions when we come back on Thursday. I finished your essay assignment. No major problem. Everybody got the 25 points. This was based upon an actual case from 2017. And all of you talked about diligence and competence. That was good. Failure to consult. That was good. Did not keep the client reasonably informed. That was good. More emphasis on not protecting the client's interest upon termination of the representation. A lot of you looked at that as 1.5. That wasn't bad in terms of fees and everything. But the money had already been spent. It wasn't a contingent fee. It was a fixed fee. And then the question is, for this unearned fee, did the attorney protect the interest of the client? He clearly didn't. More discussion about misrepresentation taken on behalf of the client. A lot of you sort of mentioned that he altered the date, but that's fraud. That's the type of misconduct that we talked about, and that impacted the representation. And then a little bit more discussion of malpractice. All of you sort of talked about the violations, but all of these violations lead up to some consequence. Some of you just said discipline could be done for malpractice, but it helps to go through the elements. So if this was an essay question, make sure you go through the elements. Duty, breach, and the breach caused some harm. Some of you mentioned the case within the case. In the actual case of this, the person